Welcome to Estate Planning Beyond the Binder.
Welcome to Estate Planning Beyond the Binder with Brian Chu, Managing Attorney of OC Wills and Trusts in Orange County, California. For more than 25 years, Brian has helped individuals and families create customized estate plans designed to protect their assets and provide clarity for the people they love. I'm LeAnn Lyon, and today we are answering a question that comes up often. If you already have a trust, do you still need a will? Brian, let's start with the basics. What is the role of a will in California, and how is it different from a living trust?
Hi, Leanne. Thanks for having me on. That's probably the first question I get all the time, even when somebody starts planning. What's the difference between a trust and a will? And they're very similar. They each document separately can appoint who's in charge of your assets when, in the case of when you pass on, and where you want those assets to go after paying off your debts. And so in that sense, they are very similar. And as we've discussed in prior episodes, and I'm sure most listeners know, the reason why we don't do just a will typically is because a will by itself cannot necessarily avoid probate for instances where you own a home. Okay. And so I do relatively few standalone wills in my practice because 99% of my clients are doing a revocable trust. And again, the trust is the same thing. It says who's in charge of assets when you can't be, and how and when the assets are going to go where you want to go. But because the trust is an entity that you create that outlives you, like a company, it allows for the transfer of control of assets from you to somebody else without having to go to court. That's really the difference between a trust and a will. A will can't do it. A will cannot transfer control. It needs the courts to get involved. The courts have to approve somebody, and they have to issue documents so that somebody can take over a bank account or somebody could take over, most importantly, a home on your behalf if you've passed on. With that being said, when we do a trust, that's the second question, is they ask you, well, why do you need to do a will? If you already have the trust, if the trust is the will. And that's the most, pretty common question I get. And the reason for that is the trust is, as I always explain to my clients, the will is a backup to the trust. The will confirms the fact that the trust is the governing document for your assets. It extinguishes any prior wills that you might have done. So there's no confusion. The trust is the governing document of who's in charge and where do things go when you're not alone, when you've passed on. So that's one of the primary purposes of the will. I'll go over in a little bit some of the other purposes, but that's the primary purpose of having a trust and a will.
Well, and I believe that's usually called a pour-over will. Am I correct?
Correct. And basically the pour-over part of a will is, instead of the will normally would say, who gets what. In this case, though, all it says is if there's any assets that somehow do pass through the will, okay, which hopefully they do not, because if everything's done properly, what's called funding your trust, if you did everything you're supposed to do, when you pass, nothing will pass through the will. But it does happen. People forget about assets. They don't properly fund their trust with their assets, and then the will get involved, and that will says everything goes to the trust. Okay. So, it is a backup. It's hopefully a backup you will never need because, and I had this happen to a friend of mine. His mom passed away. He knew she had a trust and she owned a home. And when he came to me, said, can you help me out? Can you, I want to get the house into my name. I said, there shouldn't be any problem. She had a trust. Unfortunately, when I went to look up her deed, the house was back in her name individually, not in her trust. And I had informed my friend, unfortunately, your mom, you're going to have to go to probate. You're going to have to use her pour-over will to get the house into the trust eventually. Once it gets into the trust, you can give it to yourself. But you're going to have to go through that process. And so what should have been a, $300 or $400 transaction to take care of things, he's now going to probate. And unfortunately, he had to hire a probate attorney who, unfortunately charged him $10,000, $20,000 in legal fees to get control of his mom's house. And that's where, and basically he got control of the mom's house through the pour-over will. But I was explaining to people, we're hoping the pour-over will never be necessary.
Right, for sure. Well, in practical terms, what happens if somebody creates a trust but never signs a will?
Again, since we're hoping it's never needed, if they do everything they're supposed to do, then the will won't be involved, in which case if they didn't have one, it's no big deal. So that's the goal. But, here's where the circumstance where that could be a problem, potentially. Your trust says, your assets goes to persons A and B, okay? And you have an existing, you did a will, you did a will before you did the trust, let's say, that said your assets go to person C, and you pass away and the asset turns out not to be in the trust. It's, it's a home, let's say. Well, now that will, that old will, which is still valid because that will is valid until it's, revoked or overridden by the new, by a pour over will, would say that property now goes to person C. And so that's the risk of not doing the will. Now, hopefully that's not going to be the problem, but there is some risk. People forget about bank accounts and things like that, and not so much a house, but a bank account, and thus your wishes may not have been what you wanted because an old will is coming into play. That's why we do the new will, to extinguish any prior will, so there's no confusion.
Well, let's walk through a real world example. Can you describe a situation where a pour over will made a difference because something had been left outside of the trust?
Well, what I just described actually is the two circumstances I just described. One, the asset's going to go where it's supposed to go, which is to the children, but it's going to probate. So that's because the home was left out of the trust. Okay, so in that case, because the pour over will was there, the things went where they were supposed to go. It just unfortunately didn't go the cheaper route because the trust wasn't funded. Or the example of they didn't do a pour over will at all, and the last will is in conflict with what the trust says.
Excellent. So, are there certain assets that are more likely to be unintentionally left out of a trust? You mentioned a bank account, but what other things get left out sometimes?
So it obviously depends on how the funding process goes. Like when we do a trust for our clients, we're going to take care of the real estate. We're going to take care of all personal items, clothes, furniture, jewelry, cars. So we're going to take care of that. But moving forward, my client's job is to, update their bank accounts and if they buy a new home, put that asset into the trust. And again, as long as they do their job in the future, or have us help them, then everything should be fine. Now, with that being said, there are some items that would be, I would say the unintentionally would usually be, again, it would be financial accounts. People forget about it. It could be the most common one would be a life insurance policy at work. Okay. And you don't really think about it. It's probably, you might even be free. And so that's why you don't even think about it. And so, and at the end of the day, as long as the person who is named as the beneficiary is the person you want to get the money, that's fine. Of course, the downside of that would be, though, if that person turned out to be a minor, because if you name an adult as a beneficiary on an account, it's automatic, no probate, no problem. But if they're minors, that money would go to probate. Okay, and so that's why we want to have the trust name as the beneficiary. Okay, now with that being said, intentionally, they might designate beneficiaries other than the people that are in the trust, for a variety of different reasons. And so that might be an intentional reason to keep things, outside the trust. But again, the plan is really never for the will to be involved with the assets.
Yeah,
all the will says everything. The pour over part of it says everything goes to the trust. So there's no point in having things go to the will. The will is simply as a catch-all backup in case you forgot about something.
Yeah, so let's talk about minor children you brought up just a moment ago. So for parents that have minor children, what critical function does a will serve that a trust cannot handle by itself?
The trust, in the day, the trust deals with assets, money, property, your personal items. Okay, but the one thing the trust doesn't deal directly with this is your children, in the sense of if you have minor children, who do you want to physically take care of them? Who do you want them to live with? And I'll be honest, when you have minor children like myself, the single most critical part of this planning is to who's going to take care of my kids if something happened to my wife and I.
Right.
Okay, they're going to get the money one way or the other. It's going to go to them. And yes, if I don't do any planning, things might not go exactly the way I want them to go. But at the end of the day, it's going to go to them. But more importantly, I care who I'd want to take care of the children. Because if I don't have an estate plan that talks about who the potential guardian should be, there is no voice for me and or my wife to a judge who will ultimately make the decision who should be the guardian of my children. Okay, they will just choose amongst the people who apply with whatever information they have at their disposal, but they would have no input from us. So the will is the one opportunity we have to give input if something happened to us as the parents, to a judge as far as who we'd want to be the guardian. Okay, because otherwise they have nothing from us, and they'll just go based on whatever information they have. And I want to have a say. ultimately the judge in this case would make the final decision, but what we say would carry great weight. But if we don't have a document that provides this, then we have no voice. And you know, it's because people ask, you know, why does somebody who's young, you know, as young children, why do they need to do this? You know, beyond the financial side, it's like I said, it's the guardianship issue. Again, hopefully it'll never matter, just like everything else, but you never know. And that's the single most, obviously the biggest thing. I don't want families fighting. You know, I don't want the two different sides of the family fighting over who should be the guardian. Okay. Hopefully, you know, if we say who this should be in rank order, you know, our families will respect that if that person wants to do it.
So, with regards to the quick follow-up question, is that something that has changed over the years or is state specific? Because I've heard of people putting like in their trust, this is where I want things to go. This is how I want things set up with minor children. But maybe that's something that has changed over the years?
I mean, it's still, the trust is still relevant for how you want the money to go to the kids.
Okay.
Okay. How and when and all that stuff. So that's all covered in the trust. The only thing we're covering in the will is who do they physically live with?
Okay.
And so, you know, the trust, you know, like I said, it's really important for when you have minor children, because if you name your children as beneficiaries on accounts, like I mentioned earlier, and you pass away, that money's going to probate. Okay, which will be very expensive and time consuming for your family. We're trying to avoid that. So instead of naming your kids as beneficiaries, we can now name the trust. So I don't know if it's so much changed, although I think people are becoming more aware. You know, obviously, again, the odds of something happening to you when you have minor children are pretty low, obviously, but the effects are much more devastating.
For sure.
Because, you know, it's one thing if I pass, I have adult children and, you know, they're going to get the money and yeah, maybe things didn't go as easily as it should have. That's not great, but, you know, it's not the worst thing in the world.
Right.
Again, the worst thing, you know, the thing I'm most concerned about, who, you know, the biggest influence you know, is who's going to take care of my kids. And I want to have to say.
100%. So if somebody hasn't updated their will in years, but has updated their trust, can that create problems?
The way we've set up the will, in theory, unless a relationship changes with the potential guardians, you in theory will never need to update the trust. Okay, so if you change your mind who should be the potential guardian, yes, you should you don't need to update your will. Obviously, if your relationship or you know the people who you've named as guardian wouldn't want to do it anymore, yes, you should always be updating that as often as possible if that's changed. Okay, but otherwise, at least the way we design the will. As an example, the will says an executor, the person in charge of the will, if it's ever needed, would be whoever's designated as the trustee, whoever's currently serving as the trustee of the trust. Okay. So in that sense, if you change if in your trust, obviously you might change who the trustee of the successor trustee in the trust is. Well, that will automatically change into the will, so you don't have to change the will. Okay. So it's really designed, of course, now if you have a will where it specifies the potential executors, and you've changed, you know, your order of the trustee, because your trustee and the executor should be the same person. If your will does actually specify who the executor is, yes, you would need to update that as well, if it does specify. But again, like I said, we try to design the will so you don't have to update it unless, again, you're changing guardian. Otherwise, you should never need to change the will.
Well, as we wrap up today's episode, and this is for a California homeowner who already has a trust in place, how can they confirm that their will and trust are properly coordinated?
So let's talk about, so you have your trust and then you have a will. The will should refer back to the trust. Okay. So, and here's the thing, it should refer back to the correct trust, because sometimes we have people have multiple trusts. And so, and it can only point back to one trust. Okay. Because we have some people, like I said, have multiple trusts. A married couple might have a joint trust and individual trust. Typically, the joint trust is going to be the main trust. So if something happens, we need the assets to fall to that trust. So that's one thing, I guess, in the will that you want to make sure that the trust that the will refers to is the correct trust. Okay. You know, it's not some, you know, and some people might revoke an old, you know, had an old trust they revoked and they now have a new one, and maybe they didn't update the will. Well, you want to make sure that will is directing assets to the correct trust. The other thing is, and this is part of the funding of the trust, as far as the house goes, is, you know, in this case, the will's not going to be involved, hopefully, because you've made the trust the owner of the home. And assuming you've done that on the deed. Okay. I mean, so, you know, as I always tell people, the trust cannot fund itself. There has to be a third party document, which in this case is a deed that was signed by the owners, and then again key recorded with the local county recorder, and that's what will put the house in the trust. Because if that's not done, like I said, my friend who whose mom who died with the property in her name, then the will get involved, and that's what we do not want to happen. So the will is needed just in case. Hopefully, though, it will never be needed.
Well, that is it for today's episode of Estate Planning Beyond the Binder. Even when a trust is the centerpiece of an estate plan, a will still plays an important supporting role. If you'd like to review your estate plan and make sure all of your documents are working together properly, visit ocwillsandtrustattorneys.com to schedule a consultation. And be sure to like, leave a review, and subscribe to the show so you catch every episode. Thank you, Brian.
All right. Thank you, LeAnn. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.